is, how it actually, manages things.
It's a huge challenge, absolutely. Different regions, totally different needs sometimes.
Exactly. And you've got these regional priorities, but you also need that strong central government kind of steering the ship. So how do you divide up the power, especially for really crucial stuff like, say, mining or alcohol production?
Yeah, it's a genuine puzzle. And the lines, they aren't always as clear-cut as you might think.
Well, that's what we're diving into today. Our mission is to try and untangle some of that intricate dance of legislative power. We're focusing on two really big legal battles, landmark cases, actually.
Both decided by 9-judge benches of the Supreme Court, which tells you how important they were.
Right, and they brought some, well, surprising clarity, I think, to who gets the final say on taxing mines and regulating industrial alcohol. So think of this as maybe a shortcut, a way to get your head around some pretty fundamental shifts in India's federal system.
And how these big legal decisions really shape the autonomy, the whole landscape.
Okay, so let's try and unpack the basic challenge first. How were these legislative powers actually divided up in India?
Right. The starting point is the Constitution, specifically the Seventh Schedule.
The seventh schedule. Okay. That's the architect, you could say. It lays out this division using three main lists.
Exactly. You've got List 1, the Union List. That's for subjects where the central government, the Union, has exclusive power.
Makes sense. Then list 2.
That's the State List. Power is reserved for the states. And then there's List 3, the Concurrent List.
Ah, concurrent. So both the union and the states can make laws there.
Precisely. And that's often where you see the interesting overlaps and sometimes the friction.
I can imagine.
And what's really fascinating here, I think, is that dynamic tension you always get in a federal system. It's
Yeah.
just inherent.
The push and pull.
Exactly. These lists, they're not just, administrative boxes. They are, in a way, the constitutional battleground. It's where this balance between central control and regional autonomy gets tested again and again.
So understanding that setup is pretty fundamental then.
Oh, absolutely crucial. If you want to grasp where the real authority lies and why some disputes, like the ones we're discussing, end up going all the way to the Supreme Court.
Okay.
And as we get into the specifics of the cases, we'll need to look at particular entries in these lists. So for mining, for instance, we'll see how Union List entries about industries under central control sort of mesh or clash with State List entries about, say, local mineral development or state taxes.
Right.
And then for alcohol, it's about the union's power over excise duty versus the state's traditional patch, especially when you talk about different types of alcohol. We'll mention the specific entry numbers when they become, really key to the court's logic.
Okay, that sets the stage, the constitutional map, so to speak. Like you said, the map shows the lines, but the real deep dive is how those lines get drawn, sometimes redrawn, in actual fights.
Exactly.
So let's start with mining, a really high-stakes area. The case is Mineral Area Development Authority versus Steel Authority of India, usually just called the Amade case.
Decided back in 2011. And by that powerful 9-judge bench, as you mentioned.
And the core issue, boil down for us.
Well, it was basically, can state governments put their own taxes or fees or even something called a cess, which is like a tax for a specific purpose, can they put those on mining activities?
Or does that power belong only to the central government? Especially because Parliament had already passed this big law, the Mines and Minerals Development and Regulation Act, the MMDR Act, back in '57.
Right. That was the crux of it. Does the MMDR Act, being a central law regulating mining, effectively shut the door on states imposing their own levies? Does it preempt them in legal terms?
So what did the court say? This feels like a major point of conflict.
It was. And the verdict was, well, quite significant, maybe a bit surprising to some. The court actually upheld the state's power to impose taxes and fees on mining activities.
Really? Even with the central MMDR Act in place?
Yes, but with a crucial condition. As long as those state levies don't directly conflict with the central legislation.
Okay, so there's a nuance there.
A big one. If we connect this to the bigger picture, the MMDR Act comes under the Union List, Entry 54 specifically. It deals with the regulation and development of mines and minerals under Union control. But the court said, look, that central act, while it regulates development, it doesn't automatically bar states from using their own taxing powers.
Which powers would those be?
Well, things like Entry 49 in the State List taxes on land and buildings, which could include mineral-bearing land, or Entry 50 taxes on mineral rights. Or even Entry 66, allowing states to levy fees for services rendered. The key was, Is there a direct conflict, a repugnancy with the MMDR Act? If not, the state tax could potentially stand.
Okay, wow. That distinction you just made between regulating and taxing, that feels like the absolute core of the M&D decision,
It really is.
like a aha moment. The Supreme Court drew a line, look, regulating and developing mines, mostly central under the MMDR Act. But, and this is the big but, the power to tax things related to mining, that can still be with the state, provided it doesn't step on the toes of the central law.
Exactly. It was a vital clarification. It meant states didn't automatically lose a potentially significant source of revenue just because the center was regulating the industry overall.
Okay, that makes sense. A balance was struck there.
You could say that, yes.
Right. Now, let's shift gears from digging things out of the ground to distilling liquids. Industrial alcohol. There was another major clarification here, right? A different case.
Yes, State of Uttar Pradesh versus Lalta Prasad Varsh. Much more recent. This one was decided in 2022. And again, significantly, a 9-judge bench.
9 judges again. So what was the fight about here?
The core issue was about industrial alcohol. And this is really key. We're talking specifically about non-potable alcohol, the kind not meant for drinking.
Right, not liquor for human consumption.
Exactly. Does that type of alcohol fall under the exclusive control of the union, the central government? Or could states still regulate it or maybe tax it using their own state excise acts?
So the legal question was pretty sharp then. Is non-potable industrial alcohol covered solely by, say, the Union List's Entry 84, which deals with excise duties on goods generally, and maybe that Industries Development and Regulation Act, the IDRA from 1951? Or do states get a say?
Precisely. And the court's verdict in Lalta Prasad Vash, it was, well, very decisive, much more definitive, I'd say, than May Day.
How so?
The court held that industrial alcohol, the non-potable kind, even if it comes from molasses or whatever, it simply does not fall under state excise jurisdiction.
At all.
At all, if it's not meant for human consumption. The court basically said the regulation of this non-potable alcohol is now within the exclusive domain of Parliament. Full stop.
Wow. So that state list entry, the one for excise on alcoholic liquors for human consumption, Entry 51, was it?
Entry 51, yes. The court said that just doesn't apply to industrial alcohol. It's strictly for the stuff people drink.
Okay. And did this decision shake things up regarding older rulings?
Oh, absolutely. It had a huge impact. It explicitly overruled earlier decisions, the most famous one being Synthetics and Chemicals Ltd. Versus State of UP from 1990.
Synthetics and chemicals? I remember that one.
Right. To the extent that synthetics and chemicals had seemed to give states some overlapping powers over industrial alcohol, Lalta Prasad Vash shut that down. It brought much, much clearer central control. It really ended decades of ambiguity, which, frankly, many states had used to impose their own rules and taxes on industrial alcohol.
That's a really interesting contrast with MOD, isn't it?
It is.
In MOD, states kept quite a bit of taxing power, even with central regulation. But here, with Lalta Prasad Vash and non-potable alcohol, it seems the pendulum swung hard towards exclusive central control. Why the difference? What do you think drove that?
That's a great point to zero in on. I think the difference really boils down to the specific wording, the interpretation of the constitutional entries, and the central laws involved in each case.
Okay.
For industrial alcohol, the court essentially said, look, if it's not for drinking, it's an industry.
Yeah.
And Parliament declared industries like this under union control through the IDRA. Plus, the union has that exclusive power under Entry 84 to levy excise on goods generally, which is separate from the state's power in Entry 51 over potable liquor specifically.
So the distinction between potable and non-potable was critical.
Absolutely critical. Whereas with mining, while the MMDR Act regulates development, the court found it didn't explicitly wipe out the state's separate pre-existing taxing powers, those linked to land, or mineral rights themselves, under Entries 49 and 50. It wasn't just about regulating the activity of mining, it was about taxing the resource or the land itself.
Yeah.
It comes back to that principle you mentioned earlier.
Pith and substance.
Exactly. The doctrine of pith and substance. What is the true nature, the real substance and character of the law in question?
Right. So thinking bigger picture now, beyond just mining and alcohol, what does all this tell us? What are the sort of guiding principles about India's federal system that these big cases reinforced or clarified?
Well, I think they really shone a spotlight on 3 key constitutional principles that are just fundamental to how India works. First, as we just discussed, the doctrine of pith and substance.
Yeah. Look at what the law is really doing, not just its side effects.
Precisely. It helps courts decide which list a law truly belongs to, even if it seems to touch on subjects in another list, incidentally. It's about its core purpose.
Okay, that's one. What else?
Second, repugnancy under Article 254. This is crucial for that concurrent list, List 3, where both center and states can legislate.
Right, where conflicts can happen.
Exactly. Article 254 essentially says if there's a conflict between a union law and a state law on a concurrent subject, the union law generally prevails. The state law, to the extent of the repugnancy, becomes void. This ensures some level of national uniformity where Parliament decides it's needed.
Okay, pith and substance, repugnancy. What's the third?
The third, and Lalta Prasad really hammered this home, is the exclusive control of Parliament over declared industries.
Declared industries,
Yep.
like alcohol under the IDRA or mining under the MMDR Act.
Exactly. Once Parliament, using its power under entries like Entry 52 of the Union List, declares that the control of a particular industry by the Union is expedient in the public interest, and passes a law like the IDRA or MMDR Act to regulate it, well, that significantly limits the state's power to legislate in that specific sphere.
How limited?
It can range from restricting state regulation to, as we saw with non-potable alcohol, potentially preempting it entirely, depending on the scope and intent of the central law.
So these three principles, pith and substance, repugnancy, and declared industries, they really help map out the legislative territories.
They do. They aim to bring greater clarity, reduce ambiguity, and ideally lead to more effective governance in these really important sectors, which, is vital for national economic development.
Okay, so let's try and crystallize the main takeaways for you, the listener, if we boil it down.
Yeah.
In the Mata case, the mining one, states kept the power to tax mining activities. The key was separating the center's role in regulating and developing from the state's power to tax.
Right, a division of functions almost.
Then, in Lalta Prasad Vaish, the industrial alcohol case, the line was much sharper. Only the union, only Parliament, can regulate and tax industrial alcohol that's not meant for drinking.
That's the gist. Taken together, these two massive 9-judge bench decisions have, arguably, strengthened the union's hand over these declared industries. The goal seems to be less state interference in sectors deemed nationally important, bringing, more clarity, perhaps more consistency to India's federal structure.
In understanding these rulings, it isn't just for lawyers, is it? It helps all of us grasp these deep complexities of governance, economic policy, how legal frameworks operate in a huge federal system like India's.
Absolutely. It's about who calls the shots on resources and industries that affect everyone.
So, a final thought to leave you with, perhaps. Considering these big rulings, what challenges might still pop up, regarding this balance of power between the center and the states, especially maybe with new industries, new technologies emerging all the time?
That's a really pertinent question. Are there other areas screaming out for similar clarification? Or maybe areas where these rulings might create new ambiguities down the line?
Something to ponder. We definitely encourage you to keep exploring this fascinating area, constitutional law, how federal systems actually work day to day. It's endlessly complex, but also incredibly important.